Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
How the New York Times actively vouched for the veracity of its false narrative.
We actually want all evidence to come out that's proper and appropriate evidence.
Blake Lively's lawyer quit after Brian Friedman dropped a huge update in the lawsuit, and honestly, it is not surprising to me Merle Connett was clearly drowning from day one trying to defend a case with nothing but smoke and mirrors, and let's face it, only a magician could have pulled that off.
So we kind of knew this was coming, didn't we? The collusion argument.
Quitting was likely the smartest decision to protect her reputation from sinking alongside that doomed and rapidly collapsing ship.
Look through every document. Every email, every text message.
After this news, Blake Lively's legal team is officially in chaos, and honestly, it was about time, and no one not even can blame her.
We're complicit here. You guys were involved in this every step of the way.
Defending a case that is slowly falling apart with no solid evidence to support Blake's claims is like trying to put out a fire with gasoline, and the moment Brian Friedman dropped his bombshell update, it became obvious that the case was in freefall.
The whole point of a lawsuit is you just start with allegations, and allegations are not evidence. They're just statements of fact that help establish this is the claim that I'm bringing.
At first, Blake's case seemed promising with sexual harassment, body shaming, and breastfeeding allegations offering perfect ingredients for public sympathy. But in reality, there is not a shred of evidence to support or back up any of it.
There's a lot of factual determinations that need to be made here, not legal determinations. And because there's factual determinations, you got to leave it to the jury. You got to give a jury the property.
Yeah, exactly. And so they're just saying, look, just let the facts decide. And the trier of fact in any case is going to be the jury. Unless it's a bench trial, then it's a judge. But this is not. This is a jury.
The more Justin Baldoni's team dug and the more Blake's accusations began to resemble a poorly written script with no messages, no documents, and nothing to prove. She wasn't simply making things up. Every time Blake's legal team believed they had a leg to stand on, it sank quickly.
Things that happen here.
Now here is the real kicker. Blake's PR team played a role in all of this too, because while it may have looked like they were fighting for justice, the reality was about protecting an image. They kept pushing Conan and the rest of the team to keep fighting, even though there was absolutely zero proof to support Blake's claims.
They hired, meaning the Wayfair parties, hired a crisis PR manager who orchestrated a smear campaign against Lively.
I mean, maybe they believed some classic PR spin could magically turn the case into a win, but in reality, the court does not care how many Instagram posts you make, because at the end of the day, it is all about the facts.
Surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
As if that wasn't enough, Conan was under intense pressure from every direction. Representing Blake, a high-profile client determined to win at all costs, even when the evidence simply wasn't there.
Reynolds and Lively wanted Wayfair to issue a statement taking the blame for Lively's bad press.
Then, of course, came the 170-page legal release from Baldoni's team.
Baldoni's team drops a massive $400 million suit on Blake and a lawsuit against the New York Times. Then they publish 170 pages of perfectly documented texts and emails between all the parties that basically show Blake to be the aggressor. Here's the proof.
This document wasn't just a challenge to Blake's case, it practically tore it to pieces, with the claims of sexual harassment completely unfounded and the body-shaming allegations not even close to being valid.
Yeah, and again, at the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads of theories and...
Hold that thought.
Here we go. Generally working to change the narrative. So it's impossible to know how much they planted and how much of it originated organically. Well, wait a minute.
In fact, everything Blake said was systematically debunked, and the more the case unfolded, the more it appeared that Blake was the one playing the victim, with no evidence, just a flood of claims. And the more Conan fought, the more she realized she was defending nothing.
Making a factual assertion that these people did something, seizing on it and amplifying it.
Now you might be wondering, if this was the problem, why didn't she see it coming from day one? Well, I'm not sure if you remember, but there was a time when the media giant, the New York Times, gave its stamp of approval to Blake's case, and back then it seemed like a win-win situation.
Suit against the New York Times is hard.
Poor Blake Lively's legal team probably thought they had hit the jackpot when the New York Times published an article and video in December 2024, making her claims appear practically bulletproof.
Here is
In a legal
the clip in question. Now,
complaint
this video,
liability filed on Friday.
thank you to
Private
Citizen
text
Journalist
messages.
for putting it on easily accessible. This was part of the article.
Oh, the sweet taste of mainstream media credibility, right? For a brief shining moment, it seemed like Blake had found the holy grail of support. The piece titled "We Can Bury Anyone Inside a Hollywood Smear Machine" acted like her golden ticket, a last-ditch PR move to make her accusations against Justinbaldoni and Wayfair Studios appear as legitimate as a courtroom verdict.
Campaign to tarnish Lively after she alleged that Justinbaldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct while shooting the film.
But as with most things that seem too good to be true, reality hit Blake's team harder than expected. Just when they thought they had the Times in their corner, Justinbaldoni's legal bulldog Brian Friedman delivered a counterpunch that would have knocked the wind out of anyone. Friedman wasted no time filing an opposition to dismiss the New York Times' involvement in the case, and to be honest, it was a masterclass in legal smackdowns.
The New York Times is coming back and saying, look, we're not Blake Lively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfair for.
According to Friedman, the New York Times wasn't merely reporting on Blake's allegations, they were practically presenting them as fact, framing them in a way that made it hard to tell whether it was a news article or an editorial. Friedman made it clear that the Times didn't just act as reporters, they acted as advocates.
Decided not to run it for fear of defamation, I'm sure, for fear of you and defamation. So they didn't run it, but some of these TikTokers have done it.
Friedman didn't stop at accusing the Times of bias. Oh no. He went further, accusing them of violating the fair report privilege, which protects media outlets when reporting on legal matters, the kind of protection that allows journalists to cover court cases without getting personally dragged into the drama themselves.
Mocked Baldoni in the process. He said it's an effed up bad situation with what Baldoni, whatever his name is doing.
But here's the kicker. According to Friedman, the Times didn't just report on Lively's claims, they framed them as truth. They didn't merely tell the public, Blake says this happened. They implied it had already been investigated and confirmed. That's not reporting. That's shaping a narrative.
Said Blake alleges that, or according to Blake, blah, 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 this happened, they'd be protected. But they said, and her title is investigative journalist. So she's investigative journalist for the New York Times. So that is implying that she's done an investigation. She's actually looked in this. We can trust her.
And by doing so, the Times lost the protection that comes with the fair report privilege. In other words, they exposed themselves to a lawsuit. Genius move, huh? Friedman's legal challenge was a bombshell in itself. He argued that the Times wasn't just guilty of sloppy journalism, but was actively participating in the destruction of Wayfair parties' reputations, admittedly.
Times have looked into it, and this is what really happened. So now they're stating as a fact, not as an opinion, that this happened, and that's how they're going to get into trouble.
They presented Lively's version of events as if they were not only verified, but unquestionably true. And that's a major legal problem because media outlets aren't allowed to present unverified claims as facts.
It based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times own investigation.
It's one thing to report what someone is claiming, but it's another to present it as fact, especially when you haven't done the legwork to verify it. The line between journalism and advocacy became far too blurry, and Friedman was ready to call it out.
This would be the bastion of journalism, right? But, if they had just said it's the opinion, would this have mattered? Will this factor in the fact that they did seemingly have this for months due to the metadata and things that we're seeing?
Oh, but wait, it gets better. The publication of the article and video wasn't just shady because of the framing. It was also rushed with highly questionable timing. Friedman pointed out that the Times essentially shoved the piece out during the holidays, giving the Wayfair parties almost no time to respond.
So now they're saying like, hey, we tried to fact check. We gave you the opportunity. Oh, you didn't respond. Oh, if you would have responded, we would have maybe thought of things differently. But hey, we just went with what we had, so we can't be sued. So this is what they're doing.
It was as if they knew exactly when to drop the bombshell for maximum impact. And that timing just so happened to align perfectly with Blake's PR strategy.
Here's why he's suing them. It's super creative. They said, evening of December 20th, hey, Justin, here's all this horrible stuff we're going to print about you. You have until tomorrow at noon. We'd love to hear your response. He engages with them. He says, okay.
According to Friedman, this wasn't just poor journalism. It was bad faith. The Times, it seemed, was already committed to the story before even giving the other side a fair chance to defend themselves.
And New York Times prints a story prior to noon with the partial information. And my guess is they were worried another outlet was going to hit this story.
The fact that the story had already been finalized days before the Wayfair parties were even contacted didn't look good. It made it seem like the Times wasn't interested in the truth. They were only interested in controlling the narrative.
You're talking about the Wayfair parties over here, and it to me makes it sound like the Wayfair parties did that. And again, if that's the case, if you think that that happened, investigate it. Do a series of articles. Let's see it.
Friedman didn't just take issue with the timing. He criticized the entire ethical approach behind the Times piece. It wasn't merely bad timing or poor editing. It was about the fact that the media outlet had already chosen sides.
Likely, I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
They hadn't just reported Blake's claims. They had already decided to back her, leaving little room for anyone else's version of the story. It wasn't a fair and balanced report. It was a one-sided endorsement masquerading as journalism, and for Friedman, that crossed a line.
Might as well just amend the complaint and clean it up now. So it wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
For Blake Lively, what once seemed like a golden opportunity to strengthen her case with the Times' support now felt more like a trap. What she and her team likely didn't anticipate was that backing from the media giant would turn into a double-edged sword.
The arguments were really strong, so that wouldn't surprise me either.
All right. Whew, that was.
Instead of helping her, it gave Baldwin's team the perfect opening to challenge the credibility of the entire media campaign. Friedman didn't just attack Blake's claims. He went after the media's role in amplifying them without proper verification. Now, instead of riding high on the Times endorsement, Blake's team had to fend off an entirely new legal battle over media ethics. And just when you thought it couldn't get juicier, enter Brian Friedman, Justinbaldoni's lawyer, who arrived with a full arsenal of legal ammunition. In the ongoing drama between Blake Lively, Justinbaldoni, and the Wayfair parties, the battle over jurisdiction is now taking center stage. Yes, you read that right, jurisdiction. It's the legal tug-of-war that could determine how the entire case unfolds, and spoiler alert, it's absolutely crucial.
Coordinator, and Blake refused to meet with him or denied, said, I don't need to meet with the intimacy coordinator. I'll see you on set. I'm all good. So, then Baldoni is tasked as the director with going to break down what happened when he met with the intimacy coordinator so he could get her up to date on it all.
This isn't just about where the case is filed. It's about where reputations are defended and where defamation claims could have the most impact. Friedman's strategy is focused on California, and he's making it clear that this case belongs in the land of Hollywood, not New York.
Arguing that California's tort claims, etc., damages in California are different because make their personal and professional homes, they may make claims in California.
Friedman's argument is straightforward. California law offers far more protection in defamation cases, and that's exactly what he's targeting. California is where Baldoni and the Wayfair parties are based, and it's where their reputations are most at risk.
What Justin is saying is that California's substantive law should apply on this placing somebody in a false light.
Let's face it, California is the entertainment industry's playground, so any damage to their image hits harder here than anywhere else, and you'd think that would be the first clue as to why California is the logical jurisdiction for this case.
So California recognizes a claim for damages or for money for placing somebody in a false light. New York doesn't have that same law. What Justin, I think, is correctly saying is that, hey, I'm a California guy.
The Wayfair parties' careers have taken a direct hit in California, and Friedman isn't shy about pointing that out. The New York Times may have sparked a media frenzy, but the fallout was felt most acutely where these individuals actually make their living.
These other people are in California. You, New York Times, based in New York, knew that publishing this story would impact me and others in California. So you reached out and touched us in California, so now California law applies.
California's defamation laws are also more generous when it comes to awarding damages, and Friedman knows exactly how to leverage that. He's not just aiming to win, he's aiming to make a statement. And what better place to do it than California?
I think it's extraordinarily difficult to sue a media outlet and be successful. Most of these are done just for press, like, oh, I'm suing the New York Times for all this money, and they end up getting, devastated. Here, I think he has a pathway.
Now here's the real kicker. Friedman isn't just fighting over where the case is filed. He's also calling out the New York Times for playing fast and loose with the facts. While the Times was enjoying a holiday season publishing this explosive article, Friedman was left wondering why they rushed it out without even giving the Wayfair parties a fair chance to respond.
And even if it doesn't succeed, meaning it doesn't get to a jury, or a jury says, hey, I'm going to give you $1 or something like that, I like that he's exposing this because, we hope that journalists would actually investigate completely. We hope that journalists would give each side a fair chance rather than smearing and destroying one side.
According to Friedman, the Wayfair parties had only a few hours to respond before the Times went full steam ahead and published. Classic move, right? Just drop the bomb without giving the other side a chance to defend themselves. And, of course, it gets worse because this all happened around Christmas. Perfectly convenient timing. Friedman argues that this wasn't just poor journalism. It was a deliberate attempt to push the story out without fully vetting it, a clear sign of bad faith reporting.
The hypocrisy that Blake and the New York Times were doing the same exact thing, I mean, that's hard to ignore, no?
It doesn't stop there. Friedman is ready to call out the Times for something far more serious: actual malice. Under U.S. defamation law, proving actual malice means showing that the defendant, in this case, the New York Times, knew the information was false or acted with reckless disregard for whether it was true.
That Blake is the one that colluded and conspired to get this movie and this IP out of his control so Blake could run the show. In that massive upload of documents, Blake
And Friedman has a solid case here. According to him, the Times had all the internal documents, communications, and evidence they needed to see that Blake's claims were, at best, shaky. But instead of digging deeper, the Times chose to run with the narrative they wanted to push.
Unlikely, I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
They didn't bother to double-check the facts. They just pushed out the sensational story. This is where Friedman slams the Times, not only for getting the facts wrong, but for getting them wrong on purpose. This isn't just a reporting error.
They hired, meaning the Wayfair parties, hired a crisis PR manager who orchestrated a smear campaign against Lively.
Friedman doesn't shy away from pointing out that the New York Times didn't even give the Wayfair parties a fair chance to respond to the serious accusations. It wasn't just about rushing the publication, it was about the Times actively shaping the narrative without ever considering the full picture.
The New York Times is coming back and saying, look, we're not Blake Lively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfair for.
The Wayfair parties weren't given enough time to fully present their side of the story before the article went public, and Friedman argues that this was a clear violation of journalistic fairness. The way the Times presented Blake's claims made them appear as verified facts when, in reality, they were just allegations that the Times had failed to verify.
Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
How the New York Times actively vouched for the veracity of its false narrative.
We actually want all evidence to come out that's proper and appropriate evidence.
At the heart of Friedman's challenge is the question of journalistic ethics. Was the New York Times genuinely interested in reporting the truth, or was it more about pushing a narrative? According to Friedman, the answer is obvious. The Times presented the allegations as if they were irrefutable, using their platform to give Blake's claims the weight of undeniable truth, yet they didn't take the time to investigate properly. They didn't check the facts. Instead, They simply ran with the story, and that, Friedman argues, is where they crossed the line.
Likely, I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
Then, of course, there's Lady C, a prominent figure unafraid to speak her mind about how celebrities manipulate the media. Lady C has gone full throttle on social media, calling out both Blake Lively and the New York Times for what she sees as a carefully crafted PR strategy aimed at destroying Baldwin's career, and she's not holding back. According to Lady C, by supporting Blake's version of events, the Times became an unwitting accomplice in this smear campaign.